Can you pursue a workers' comp claim when you are hit by coworkers who are playing a joke? This situation arose in a fact pattern in Virginia where this Mr. Ocasio was walking in a parking lot and he was hit by his coworkers who were playing like a prank with a golf cart. So they were just joking around, and sometimes jokes end up not being jokes. In this case, the guy got hit and he suffered some type of injury. So he filed a workers' comp claim in Virginia, and he also filed a personal injury suit against the person who was driving the golf cart. Virginia ultimately, the Court of Appeals basically said he wouldn't be able to pursue a workers' comp claim, but instead his sole remedy would be a personal injury suit against the person that hit him. So that's Virginia. That's interesting because that's not how it would work in Ohio. In Ohio, there's something called the Fellow-Employee Doctrine. So, and if you're injured due to the negligence of one of your fellow employees, you can't then go and sue your fellow employee. If it happened in the course of and rising out of your employment at your job, it's a workers' comp claim. And that's the exclusive remedy in that situation. So the other question is that this kind of came up in this case in Virginia, was this idea of horseplay. Well, that's a defense to workers' comp claims. In Ohio, horseplay. So, and the idea is, if you are the injured worker and you are engaging in horseplay, i.e. you're on a forklift and you're racing your coworkers in forklifts and your forklift toppled over and you suffered an injury, well, the employer would be able to say, yes, you got injured, but you were doing something that deviated from your job and you're engaging in horseplay. But what about this instance if you're the victim of somebody else's horseplay? Like this Mr. Ocasio, he's just walking a parking lot and he gets hit by these goofballs who are driving the golf cart. They're playing a game, they're engaging in horseplay, but he's not. He's just a victim of horseplay. In that instance, he would still have a workers' comp claim because he's not the one engaging in the horseplay. And the employer, they can't use that defense in this instance because he's just the victim of somebody else's horseplay, not a participant in the horseplay itself. So assuming everything else is copacetic and it happened in the course of an arising out of his employment with his employer, he would be able to file a workers' comp claim. The workers' comp claim may be allowed. And the defense would not be asserted. But what he would not be able to do is, again, he would not, because of the Fellow-Employee Doctrine, he would not be able to turn around and sue the person for personal injury tort. The goofballs who hit him with the golf cart. So that's how Virginia does things versus how Ohio does things.